Good afternoon, everybody. So today in this video, we will be discussing the concept of trial as given under the Code of Criminal Procedure Code of 1973. The trial begins as soon as the cognizance of any offense is taken by a magistrate under Section 190. Trial, if it is asked that what does a trial means? Trial is the judicial adjudication of the innocence or the guilt of the accused who is brought before the court. And under our criminal law, we have various kinds of trials, like trial before a court of session, trial of warrant cases, trial of summon cases, and obviously the summary trials. So we will be discussing them one by one. So first of all, we'll be discussing about the trial before a court of session. Now, in respect of the offences which are punishable with death, life imprisonment, or imprisonment for a term exceeding 7 years, the trial is conducted in a session court after being committed or forwarded to the court by a magistrate. So sometimes the questions may be asked that in what kinds of offences the trial by a session court will be conducted. So wherein the offences which are punishable with death, life imprisonment, or imprisonment for a term exceeding 7 years. Now, this procedure for a trial before a court of session has been given under Section 225 to 237 of Criminal Procedure Code. Now, in the case of Bhagirath versus State of Madhya Pradesh, AIR 1976, Supreme Court 975, it has been held that once the trial has started, the session judge must, except for a very pressing reason which makes an adjournment inevitable, proceed de indiem until the trial is concluded. So the steps which are involved in the trial before a court of session are as follows. The very first, as given under Section 225, is that the trial before a court of session should be conducted by a public prosecutor. As per Section 225 of CrPC, in every trial before the court of session, the prosecution shall be conducted by a public prosecutor only. Now, Section 226 talks about the opening case for the prosecution. It states that when the accused appears or is brought before the court in pursuance of commitment of the case under Section 209 of CrPC, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. Now, if the public prosecutor knows at the stage itself that certain persons cited by the investigating agencies as witnesses might not support the prosecution case, he is at liberty to state before the court that fact. This was held in the case of Hukum Singh versus State of Rajasthan 2001, Criminal LJ 511, Supreme Court. The next is the discharge of the accused as under Section 227. It states that after considering the record of the case and after hearing the submission of both the parties, if the court considers that there is no sufficient ground for proceeding with the case against the accused, it shall discharge the accused and shall record his reasons for doing so. Now, if the court thinks that there are sufficient evidence to proceed against the accused, then the next stage will come in, which is under Section 228, which is the framing of charges. Now, after considering the record of the case and after hearing the parties, if the judge considers that there is ground for presuming that the accused has committed an offense which is exclusively triable by the sessions court, that court shall frame in writing a charge against the accused as per Section 228, subsection 1. The charge shall be read the accused, and the accused shall be asked whether he pleads guilty of the offence charged or claims to be tried, as given under Section 228, subsection 2. Now, Section 229 talks about conviction on plea of guilty. Now, if the accused pleads guilty, then the judge must record such a plea, and in his discretion, he may convict him on such plea. Then and there itself, the accused shall be convicted. Now, if he does not, then the trial will proceed. After that, a date for prosecution evidence will be fixed as per Section 230. It states if the accused refuses to plead guilty or does not plead guilty or claims to be tried or is not convicted despite pleading guilty, the judge must fix a date for examination of witnesses. On application of the prosecution, the judge may also issue process for compelling the attendance of any witness or the production of any document. Now, the next step is the evidence for the prosecution, which is given under section 231. Now, on the date fixed as mentioned above, as mentioned under section 230, the court shall proceed to take all the evidences as may be produced in support of the prosecution. The court may permit the cross-examination of any witness to be deferred until any other witness has been examined or recall any witness for further cross-examination. After that is the acquittal of the accused, section 232. Now, when does that come into play? Now, after the taking the evidence for the prosecution, examining the accused, the court shall hear the parties, that is both your prosecution and the defense side. And then if it considers that there is no evidence that the accused has committed the offense, it shall record an order acquitting him under section 232. Now, next is the evidence for defense, which has been given under section 233. It states that if the accused is not acquitted, he shall be called upon to enter on his defense and adduce any evidence in support of his defense. And if the accused submits any written statement, the judge must file it with the record. Now, if the accused applies for the issue of any process for compelling the attendance of any witness or the production of any document or anything, the judge shall issue such process unless he considers, for reasons to be recorded, that such a process shall be refused on the ground that it is made for causing delay and for defeating the ends of justice. The 10th point is your arguments. Now, when the examination of the defense witnesses is complete, then the prosecutor sums up his case and the accused or his pleader shall be entitled to reply. Where any law point is raised by the defense, the prosecution may be allowed to make his submissions with regard to such point of law. So this was all about your trial before a court of session. I'll again just repeat the points. The very first is the trial that as per section 225, the trial shall be conducted by the public prosecutor. As per section 226, the 226 talks about the opening case for the prosecution. 227 talks about the discharge of the accused. 228 talks about framing of charges. 229 is conviction on plea of guilty. 230 is fixing the date for prosecution evidence. 231 is the evidence for the prosecution. 232 talks about the acquittal of the accused. 233 talks about the evidence for the defense. And 234 talks about the arguments. Now, this takes us to the next trial, which is the trial of warrant cases by magistrate. So now, as I've already pointed out that, trial of warrant cases by magistrate are divided into two categories. Cases instituted on police report and cases instituted otherwise than on a police report. Now, in cases instituted on a police report, it has been given under section 238 onwards to section 243. The very first step that is there is the compliance with section 207. What does compliance with section 207 means? That in any warrant case which is instituted on a police report, the accused appears or is brought before a magistrate at the commencement of the trial. The magistrate shall satisfy himself that he has complied with the provisions of section 207, that is, all the copies of FIR and the statements recorded have been given to him. Section 239 talks about when accused shall be discharged. Now, if upon considering the police report and the documents sent with it under section 173 and making such examination, if any of the accused as the magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate considers the charge against the accused to be groundless, he shall discharge the accused then and there itself and shall record his reasons for doing so. Section 240 talks about the framing of charges. Now, if upon examination or hearing, the magistrate is of the opinion that there is a ground for presuming that the accused has committed an offense, which is triable under this chapter, that is chapter 19 of CrPC, then, he shall frame in writing the charges against the accused. and the charge shall then be read and explained to the accused, and he shall be asked whether he pleads guilty or not. Then section 241 talks about the conviction on the plea of guilty. Now, if the accused pleads guilty, he will be convicted then and there itself. 242 talks about evidence for prosecution. Now, if he does not plead guilty, then, a date will be, the magistrate on the application of the prosecution may issue a summons to any of the witnesses, and the witnesses shall be asked to produce themselves before the court and answer in relation to the trial that is going on. And on the date so fixed, the magistrate shall proceed to take all such evidence which have been produced. Then 243 is the evidence for the defense. The accused then shall be called upon to enter upon his defense and produce his evidence. And if the accused puts in any written statement, the magistrate shall file it with the record. Now, if the accused, after he has entered upon his defense, applies to the magistrate to issue any process for compelling the attendance of any witness or to produce any document or anything, no, such application can be allowed, but it can also be refused if the magistrate thinks that the accused is doing it deliberately to defeat the ends of justice. Then, this is some of the, basic, the similarity which is, in trial of cases instituted on police report. Now, in cases instituted otherwise than on police report, it starts from section 244. It talks about the evidence for prosecution. Now, in a warrant case which is instituted otherwise than on a police report, the accused appears or is brought before a magistrate. The magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. The magistrate may, on the application of the prosecution, issue a summons to any of the witnesses directing them to appear before the court. 245 talks about the conditions wherein the accused shall be discharged. Now, if upon taking all the evidence referred to in section 244, the magistrate thinks that there is no case which is made out against the accused, then the magistrate shall discharge him. Now, the provision to subsection 2 of section 245 states, nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case, if for reasons to be recorded by such magistrate, he considers the charge to be groundless. Now, section 246 talks about, procedure where accused is not discharged. Now, when such evidence has been taken or at any previous stage of the case, the magistrate is of the opinion that there is ground for presuming that the accused has committed an offence triable under this chapter, which such magistrate is competent to try and which in his opinion could be adequately punished by him, he shall frame in writing a charge against the accused. The charge shall be read over to him, explained to him, and asked whether he pleads guilty or not. If he pleads guilty, the plea shall be recorded, he shall be convicted then and there itself. Now, if he does not, then the date shall be fixed for evidence. Now, this was all about, the beginning part of the trial of warrant case instituted on police report and otherwise on police report. Now, the conclusion of trial. How does the trial? What are the last part? Now, section 248 talks about the acquittal or conviction. Now, if in any case under this chapter, which is chapter of trial of warrant cases by magistrate, a charge has been framed, the magistrate finds the accused not guilty, he shall record an order of acquittal. Similarly, where in any case the magistrate finds the accused guilty but does not proceed in accordance with section 325 or section 360, he shall, after hearing the accused on the question of sentence, pass sentence upon him as per law. As per subsection 3, where in any case under this chapter, a previous conviction is charged under the provision of subsection 7 of section 211, and the accused does not admit that he has been previously convicted as alleged in the charge, the magistrate may, after he has convicted the said accused, take evidence in respect of the alleged previous conviction and shall record a finding thereon. So, before we proceed further, I would just like apprise once again about the just quickly about the trial of warrant cases. So, trial of warrant cases has been divided into two categories: cases instituted on police report and cases instituted otherwise than on police report. The cases instituted on police report have been, dealt with under section 238 onwards, 243. 238 talks about compliance with section 207. 239 talks about when the accused shall be discharged. 240 talks about framing of charges. 241 is conviction on plea of guilty. 242 is evidence for prosecution. 243 is evidence for defense. Then cases instituted otherwise and on police support have been given from under section 244. 244 is evidence for prosecution. 245 is when accused shall be discharged. 246 is procedure when accused is not discharged. 247 is evidence for defense. And part C deals with the conclusion of trial, which is an order of acquittal or conviction. Vishu? So now we will be dealing with the trial of summon cases by magistrate, which has been given under chapter 20 or section 251 onwards. So section 251 talks about substance of acquisition to be stated. Now, when in a summon case, the accused appears or is brought before the magistrate, the particulars of the offense of which he is accused shall be stated to him, and then he shall be asked whether he pleads guilty or has any defense to make. But it shall not be necessary to frame a formal charge. Now, section 252 talks about the conviction on plea of guilty. If the accused pleads guilty, the magistrate shall record the plea as nearly as possible in the words of the accused, and in his discretion, then convict him thereto. Now, section 253 talks about conviction on plea of guilty in absence of accused in petty cases. Now, where a summon has been issued under section 206 and the accused desires to plead guilty to the charge without appearing before the magistrate, he shall transmit to the magistrate by post or by messenger a letter containing his plea and also the amount of fine specified in the summons. The magistrate may, in his discretion, convict the accused in his absence on his plea of guilty and sentence him to pay the fine specified in the summon, and the amount transmitted by the accused shall be adjusted towards that fine. Or where a pleader authorized by the accused in this behalf pleads guilty on behalf of the accused, the magistrate shall record the plea as nearly as possible in the words used by the pleader. Now, section 254 talks about procedure when not convicted. Now, if the magistrate does not convict the accused under section 252 or 253, the magistrate shall proceed to hear the prosecution and take all the evidence as may be produced by the prosecution, and shall also hear the accused and shall take into consideration the evidences which have been produced by the defense side. The magistrate may, if he thinks fit, on the application of the prosecution or the accused, issue a summon to any witness directing him to appear before the court. The magistrate may, before summoning any witness on such application, require that the reasonable expenses of the witness incurred in attending for the purpose of the trial be deposited in the court. Then 255 is the last one, which is the order of acquittal or conviction. If the magistrate, upon taking the evidence referred to in section 254, and such further evidence, if he thinks, that finds the accused not guilty, he shall record an order of acquittal. But if he finds him guilty, then shall record an order of conviction. So this was all about the trial of summon cases by magistrate. Vishu. So now we'll be dealing with summary trials. Now, summary trials have been given under chapter 21 from section 260 to 265 onwards. Chapter 21 deals with the procedure to be followed in summary trials. A summary trial implies speedy disposal. A summary case can be tried and disposed of at once. Thus, it is not intended for contentious and complicated case which merits a full and lengthy inquiry. Now, the following 9 offences have been singled out by section 260 subsection 1 for summary trials. Offences not punishable with death, life imprisonment or imprisonment for a term exceeding 2 years. Theft, section 379 to 381 of IPC, of property not exceeding rupees 2,000. Receiving or retaining stolen property not exceeding rupees 2,000. Assisting in the concealment or disposal of such stolen property. Lurking house trespass under section 454 and 456 of IPC. Insert with intent to provoke a breach of the peace. Section 504 of IPC. Criminal intimidation punishable with imprisonment for a term which may extend to 2 years or with fine or with both. abatement of any of the foregoing offences as mentioned above, an attempt to commit any of the foregoing offences when such attempt is also an offence, any offence constituted by an act in respect of which a complaint may be made under Section 20 Cattle Trespass Act of 1871. Now, what is the procedure to be followed in summary trials? Now, in summary trials, the procedure specified for the trial of a summon case is to be followed. Now, Section 262, subsection 1, talks about the following three qualifications. No sentence of imprisonment for more than 3 months can be passed in any conviction under this chapter, Section 262, subsection 2. In every case tried summarily, the magistrate must enter the following particulars: serial number of the case, date of the commission of the offence, date of the report or the complaint, name of the complainant, name, parentage and residence of the accused, offence complained of, plea of the accused and his examination, the findings, the sentence or the final order, date on which the proceedings were terminated, Section 263. Now, in every case which is tried summarily, in which the accused does not plead guilty, the magistrate shall record the substance of the evidence and a judgment containing brief statement of the reasons for the finding as given under Section 264. Now, as per Section 265, every such record and judgment shall be written in the language of the court and signed by the magistrate. Now, a sentence exceeding 3 months cannot be passed in summary trials. If the court considers that a longer sentence is necessary in the interest of justice, the trial should be held as in a warrant case or a summon case according to the nature of the offence. This was held in the case of Nandalal Harishankar, AIR 1969. Now, the record of a summary trial is kept in the form prescribed by the state government. Now, in summary trial, a formal charge is not framed, nor the evidence of the witnesses is necessarily recorded. In a case, the magistrate convicted and accused summarily of an offence without issuing any process or making any record of the proceedings, and without even dismounting from a pony on which he was riding. It was held that entire procedure was illegal. Now, Section 265 permits the preparation of, record or judgment by means of an officer appointed by the Chief Judicial Magistrate. And such record should be made at the time of trial and not afterwards. This was all about the concept of trial. If there's any question, please let us know. We will answer them.